Court does call the case people versus James Williams.
Trevor Maybell for the people, Your Honor.
On behalf of Mr. Williams, who should be appearing by Zoom.
We don't have him, and his Zoom appearance would have been revoked.
I'm sorry, say it again.
It would have been revoked because of the violation report.
He says he's on.
He needs to appear in person. Why is he missing?
He's at work right now.
No. Why is he missing testing?
Oh, Your Honor, I didn't.
You don't have the violation report?
No, and I looked through.
Well, it's rather empty, so it'd be quick for you to get through because he doesn't go. Read faster than that. It can't take that long because there's spaces.
And Your Honor, I have not spoken to my client regarding missed tests or not going.
Where is
testing.
he now?
He is. He's at work in. I believe it's the Detroit area. Where are you?
We're all in the Detroit area. I don't know what that means. Here's what I'm going to do for you, Miss Cannon. You'll be able to talk to your client. Mr. Williams? Hello.
Is there?
Here's what I'm going to do. I'm going to adjourn your probable cause conference 1 week to October 16th, correct? 2025. 9 a.m. as your invite indicates. You've got some problems with your testing and a violation report. You need to appear at that time, and this will be an in-person hearing. You cannot appear via Zoom. Bond will continue.
Thank you so much, Your Honor.
You're welcome. That was a nice thing I've done today. That's it. Super. Court calls the case People versus Damian Williamson.
That's people. So, Your Honor, I will get him. He's here with his that he came in. He was out in the hall with his baby. I'm sorry.
What? He was out in the hallway with the baby.
Yes.
Is that his?
Yes.
Okay. Might need to ask sometimes, Simon. How you doing? I'm doing well.
Afternoon, Judge Michael Gaddy, Assistant Public Defender, on behalf of Mr. To my right, state your name, Mr. Williams.
Damian Williamson.
Your Honor, I have discussed. We have submitted a green sheet here. I'm asking for an adjournment while we continue discussing plea.
I will adjourn. Probable cause will be adjourned to November 6, 2025, 9 a.m. Bond continue.
Thank you, Judge.
Thank you, Your Honor.
Thank you, sir.
Have a good day.
You too.
That's 3 o'clock.
This is 3. Yeah, now I'm going.
Judge Simpson walks into the courtroom already sensing tension. The docket is stacked with difficult cases, and the first defendant shows up ready to argue. He refuses to answer basic questions, repeatedly interrupting the judge. Simpson keeps his tone controlled, but the frustration builds as the defendant pushes every boundary. The courtroom goes completely silent when the judge finally warns him that one more outburst will lead to immediate custody.
Court calls case of the People versus Jennifer Burnside.
As well as with people.
Good afternoon, Your Honor. Jason Hagelstorm here on behalf of Defendant Jennifer Burnside, who is present.
Good afternoon. All right. What are we doing?
We're going to ask for an adjournment to further discuss some plea deals that are proposed.
Okay. You have a medical marijuana?
Yes, Your Honor, but I am going to...
Your Honor, for clarification, Ms. Burnside does have a medical marijuana card. She has ceased the use of that at the time of arraignment. There are positive, I received this report on the 12th and the 19th. I would suspect that if there were numbers included, those are going to be decreased, and she's assured me of that. There's a dilute on the 23rd. That is... We're at a loss as to why that would happen. I've advised Ms. Burnside, and she has agreed that if there were errors in testing, she would appear and go to the ER, get a blood test to double verify that. She's taken drastic steps to maintain sobriety. She's attending AA twice a week since the time of arraignment. She's got a upcoming meeting with Dev over at Dawn Farms for an outpatient review. She's participating with the state police Angel program. She has a program peer recovery coach. She's volunteering and she is attending services with her church as well as Celebrate Recovery on a regular basis. So with those steps, I'd ask the court to consider, she's been advised that she should check with the facility she tested today. I told her, if you are, make sure that there's not a dilute.
Correct.
We're just
that looks worse than.
And I think, Your Honor, the part of the reason why this case, we did ask for both the scram and the testing is because this is an OWI third offense where there was both 0.106 of alcohol and cocaine present in the defendant's system.
Correct. Okay. I'll adjourn it out. Will the 30th work for you, counsel? Or you want
30th will work, Your Honor.
probable cause will be adjourned October 30th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Amber Cormos.
That's both for the people.
Good afternoon, Your Honor. Jay Grant Miller, P58658, on behalf of Ms. Cormos, who stands to my right. Please state your name.
Amber Cormos.
Your Honor.
For an adjournment, counsel.
Yes, we're continuing some negotiations towards possible resolution. We would ask for a date in November as Ms. Cormos is undergoing a medical procedure that might help myself and the prosecutor better lay out a future.
November 13th.
That would be fine.
November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Yep, Bond continued. Court calls case of the People versus Armorel Gold.
That's both for the people.
Good afternoon, Your Honor. Dan Garrett on behalf of Ms. Feldman. State your name.
Armorel, go.
There's a green sheet for screening into sobriety court, please.
All right. Do you know what track they're on and how different? Okay.
I think we.
Which is it for the 22nd, sir? Judge Monkey, or which court are you?
Oh, I'm sorry, Your Honor. It's 14A1.
Oh,
yes. You may know the track.
We're quick.
All right. Yeah.
I'll put it out to November, or not November. I'll put it out October 30th.
Perfect.
2025, 9 a.m.
Next up is a landlord-tenant dispute that's been dragging on for months. Both sides arrive with stacks of papers and loud accusations. The tenant refuses to acknowledge previous warnings, while the landlord keeps interrupting the judge. Simpson eventually slams down the discussion, reminding them that this courtroom is not a shouting match. He delivers a strict ruling, leaving both parties stunned.
Bond will continue.
Thank you.
Thank you.
All right, thank you. Court does call the case People versus Tyler Van Effen.
That's both for the people.
Good afternoon again, Your Honor. Dan Garrett on behalf of Tyler Van Effen.
Tyler Van Effen. All right. Requesting an adjournment.
I am, Your Honor, for further negotiation.
Let's put it over that same date for you, October 30th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case of the People versus Beverly Joe Tuttle.
That's both for the people.
Good afternoon, Your Honor. Well, P42505 on behalf of Ms. Tuttle, who's on Zoom.
Ms. Tuttle.
Good afternoon, sir.
Good afternoon. Okay, you got her. Okay. What are we doing?
Your Honor, we'll request an exam.
No discovery complete.
Yes.
People have their witnesses available the 21st?
We'll try, Your Honor, for both cases.
Yes.
We'll try.
What date, Judge?
The 21st.
Not available on that day, sorry. In a jury trial in Third Circuit. Second day of a jury trial, sorry. I think we'll be done. So I'm available on the Thursday, the 23rd, or it has to be a Tuesday.
You've been coming here how much?
Don't recall.
Then you should know what day our exams are held. It's Tuesday.
I'm available, Judge. Thank you.
Preliminary examination in person, October 28th, 2025, 9 a.m. That's before Judge Washington.
Thank you, Your Honor.
Thank you, Judge.
Bond will continue.
Thank you.
Case People versus Richard Halstead.
Ashley Felton.
Good morning, Your Honor. Well, not good morning.
No, it's not.
Yeah, I know. It just feels like you're living in it.
Hey, what the heck?
Well, good afternoon, Your Honor. Brandon Bird on behalf of Richard Halstead. Mr. Halstead, can you please state your full name for the record?
Richard Lee Halstead Jr.
Thank you, sir. This plea form we have, is that what we're doing?
Correct, Your Honor. And we're also asking him for immediate sentencing in this matter. I know usually you might not do it in a case like this, but he just got off probation for you yesterday for the same incident. They charged the drug paraphernalia as the city, and then when he was about a couple months off probation, they came with the felony charges. But he successfully completed probation in this matter. I did talk to the prosecution about this matter, and they said they have no objection to automatic sentencing and no objection. He spent a week in jail when he capious and turned himself in. So no objection to having that as time served.
Today.
That's why I'm trying to make it quick. You see, I'm trying to spit it out.
No, you just kept going. I heard you up until about the third word, and then I stopped listening. I don't mean. I'm not going to immediately sentence. It's not what I do. Not on this case.
Okay.
That's fine, Your Honor. Thank you.
Fine, Your Honor. We can just get it out of the way.
I could have stopped you, but what the heck? Let you talk.
A young offender enters with defiant attitude, shrugging and laughing at the seriousness of the charges. Judge Simpson tries to explain the consequences, but the teen mocks the process. The judge pauses, looks directly at him, and shifts to a firmer approach. The tone in the room changes instantly as Simpson lays out consequences that finally wipe the smirk off the teen's face.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Richard Halstead.
Sir, it is the court's understanding that you're going to plead guilty to the charge of use of controlled substance. That's a misdemeanor punishable up to 1 year, $2,000 fine plus court costs. You understand that?
Yes, sir.
And because I didn't say so, part of the agreement form here indicates that count one would then be dismissed. You understand that, sir? All right. Still wish to plead guilty to all this?
Yes.
And to that charge, how do you plead?
To the usage?
Pardon?
Usage charge?
To the use?
Yes.
How do you plead?
Guilty, I'm sorry.
Sorry. You understand that by pleading guilty, you'll not have a trial of any kind.
Right.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this charge?
Yes.
All right. On the date, if I can find it. On the date of January 7th, 2025, at the location of Michigan Avenue, US 23 in Pittsfield Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes, sir.
Did you use it?
Earlier in the night, yes.
And you knew what you were using was cocaine?
Pardon me?
And you knew what you were using was cocaine?
Yes.
All right. Sir, if I accept your plea, I do have to advise you that if between the time of my acceptance of your plea and your time of sentencing, if you commit misconduct as defined under the Michigan court rules, The court would no longer be bound by any sentence evaluation, and you would not be entitled to withdraw your plea. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
I'm not, Your Honor.
No, Your Honor.
All right. And as the court complied with the court rule, would it be proper to accept the defendant's plea?
The people are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be November 12th, 2025, 9 a.m. Bond will continue. All right. Thank you.
Have a great day. You and your honorable court.
You too, sir.
Thank you.
Court calls case People versus Eric Fitch.
Trevor Mabo for the people.
Afternoon, John Minnick on behalf of Mr. Fitch.
Okay, and he's waiving?
That's correct.
All right, sir, you signed this examination waiver?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and you committed it?
Yes.
You understand you'll not have that here and you'll proceed to circuit court for further resolution?
Yes.
People also waive the right?
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Minnick, as to the circuit court arraignment.
He stands mute. We waive the reading of the information.
Defendant never waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
December 9th, p.m. with Judge Simpson.
December 9th, 2025, 1:30 before Judge Coffey.
Thank you.
Thank you. Bond continue. Court calls case People versus Adrian Harris.
Ellison on behalf of the people.
Good afternoon, Your Honor. Robert Ellman with it on behalf of Mr. Harrison who's approaching. Mr. Harrison, can you please state your name for the record?
Adrian Harrison. Thank you, sir.
Your Honor, we'd like to set this matter for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 21st.
We'll do our best, Your Honor.
Preliminary examination in person, October 21st, 2025, 9 a.m. That's before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continue. Case of the People versus Eric Lightheart.
Good afternoon, Your Honor. Mr. Simpson, we have my client who approaches.
The final case of the day is the hardest. A family disagreement has spiraled into criminal charges, and emotions overflow. Voices crack, accusations fly, and the entire courtroom feels tense. Judge Simpson listens carefully, balancing compassion with firmness. In the end, he delivers a tough but fair decision that quiets the room. Even the attorneys nod, recognizing how difficult that judgment truly was.